listening to the Hunter Conservationist Podcast. Thomas King is a novelist. He is a companion of the Order of Canada and a winner of a Governor General's Literary Award. King is often described as one of the finest contemporary Indigenous writers in North America. He's written quite a few books and screenplays and stuff. The one book I'm most familiar with is called The Inconvenient Indian, a curious account of Native people in North America. And in his book, he says this: sovereignty is one of those topics about which everyone has an opinion. And each time the subject is brought up at a gathering or a conference, a hockey game breaks out. To be honest, I'm reluctant to mention it. But if you're going to talk about Indians, his words, in contemporary North America, you're going to have to discuss sovereignty. No way around it. One of the things that I took away from his book, what he kind of wrapped up with and left the reader with, was my interpretation that the foundation of sovereignty is a place to be sovereign, and that's land. And I can appreciate that. I think that's what we see Alberta going through right now in wanting sovereignty, and they need their land and their resources in order to be in control of their own destiny. In Canada, there's about 2 million Indigenous people. So that's First Nations, Inuit, and Métis people. We've been covering stories on all these Indigenous groups in Canada, in the areas of wildlife management, conservation, science, hunting, trapping, access to land, going on 7 years now. And so much of what we cover is about conflict. The East Coast fisheries have been covering, the conflict over the lobster fishery, the Elvers fishery, which revolve around the Marshall decision and the right to moderate livelihood. Quite a few conversations here in British Columbia about the banning of grizzly bear hunting, and it's still a protected constitutional right of Indigenous people to hunt grizzly bears and manage them. In Manitoba, it's a real hot spot in Canada right now with a number of large Indigenous protected conservation areas that are being proposed, which if they go through would, as we see it, because they're using the National Park Act to implement these, would exclude licensed hunters, anglers, trappers, and hunting outfitters and fishing outfitters. The Manitoba Wildlife Federation is trying to be heard by advocating for a lack of public process around these Indigenous protected conservation areas. There's lawsuits in Manitoba over these. There's lawsuits over licensed moose hunters in the northern part of Manitoba. We see stories in Canada of First Nations fighting the Métis people, not wanting Métis people to see the expansion of their rights in Canada when it comes to lands and practicing, their rights. We've recently seen these whole narratives pop up about stolen land and an MLA in BC that wanted to label non-Indigenous people as settlers. And, I don't like either of those narratives, regardless of who they're coming from. It's not fostering dialogue. It's just creating division because they're trigger words for people in a lot of different ways. Several years ago in British Columbia, there was a Supreme Court, a Supreme Court decision called the Silkatine decision. There's actually been a few Silkatine decision cases, but the latest one that I'm familiar with the courts awarded the Silkatine people 1,700 square kilometers of land. Instantly, with the judge's gavel, that land became Silkatine land. The guide outfitters who had guide outfitting territories in that, where basically they could no longer operate on Silkatine's land, and their compensation package for the loss of their guide outfitting territories just last year was rejected by the Treasury Board. So they got nothing out of that. Recently, we've seen a decision where the island of Haida Gwaii was given to the Haida people to govern, and recently talking to somebody who was there fishing, there's a lot of uncertainty around private land real estate, people putting their places up for sale, the Haida people buying real estate that's being put up for sale. It goes on. A few years ago, the Yehi decision in British Columbia was a Supreme Court decision about the cumulative impacts of resource development in the Blueberry River First Nations territory. When that decision came down, the judge basically said the government was doing a bad job of managing impacts to the lands of the Blueberry River First Nations people. And so the province responded by cutting moose tags for resident hunters and outfitters in the area, which had nothing to do with the decision. This spring, we saw, I guess, press releases by some First Nations basically closing Crown land to the morel mushroom pickers of the forest fires. In some ways, I can't blame them, because those commercial pickers that are coming in from all over North America kind of make a mess. We've seen a lot of controversy about the closure of BC parks in British Columbia, whether they're short-term or longer-term. We published an article, one of our team writers, Larry Brandt out of Manitoba, produced what I thought was a thoughtful article around the BC Parks closures last month. It's called "When the Gates Close, What BC Park Restrictions Reveal About the Deeper Failure of Reconciliation," and that's on the Blood Origins website. Here in BC, there's over 60 at last count that I know of First Nations who have put proposals into the provincial government for Indigenous protected conservation areas. Nobody really knows what that might mean for land access. I do know one of them in the lower Similkameen area would be full exclusion of resident hunters and recreationalists. And just kind of finally, my understanding of this whole situation, coast to coast to coast in this country, is, pretty much Canada has treaties, all across the country. In Nunavut, they have the Nunavut Lands Claim Agreement. It's not really a treaty. BC and the Yukon, from what I understand, have the most amount of unsettled treaties with First Nations. So we do see a lot of the land type conflicts, I think, in Western Canada, BC, and more so starting to happen in the Yukon. The rest of Canada seems to be more about who gets to use the resources, fish, wildlife, that sort of thing. Nunavut, they have, under the Nunavut Lands Agreement, they have areas, harvesting areas, which are only for Inuit people. And if you live in Nunavut and you are a non-Inuit person and you want to go hunting, you can't hunt in the Inuit designated areas. And as far as I know, it's working. It's a segregation of people based on culture and traditions. I've never heard anything controversial about that under the Lands Claim Agreement. Here in BC adopted the United Nations Declaration of Rights of Indigenous People and converted it into the Declaration of Rights of Indigenous People Act, so a provincial statute. And that's been in the news lots, with a lot of controversy around this term, vetoing, First Nations having veto powers, which, interestingly enough, the UN Declaration does not have that. The countries that ratified it opted for an article that was a way out, and they did not consent to the term veto, but it comes up in BC. So this is going to be a good episode. Our goal here is not to be scared to talk about, this topic. It's to learn. It's a topic that's on everyone's mind. So we're looking forward to having a mindful conversation with Caroline, and we're just here to respect everybody's perspectives and analysis of the situation, and we're just here in the business of providing information for all your folks, and I think we have to hear from all corners. Probably what we're underrepresented in is getting some Indigenous leaders specifically talking about these stories. We've had Indigenous leaders on the show before talking more about the hunting side of things, not so much around, some of these land access things. So we're working on it, and we're here for everybody. Hey, everybody, it's Mark Hall, your host.
And it's Curtis Hall, your co-host. The Hunter Conservationist podcast is brought to you by J. Martin Taxidermy. If you're looking to preserve your most memorable hunting experiences, look no further than J. Martin Taxidermy, based in West Kelowna, British Columbia. Founded by Jesse Martin, an Okanagan native with strong hunting background, this family-owned business delivers exceptional craftsmanship and attention to detail. Jesse honed his skills at the renowned Penn School of Taxidermy, combining technical training with a true passion for the art of taxidermy. J. Martin Taxidermy runs a modern, fully equipped studio capable of handling all your taxidermy needs. Whether you're local or international, J. Martin Taxidermy provides everything from permit handling to shipping with professionalism and care. Visit jmartintaxidermy.com and let your hunting memories last a lifetime. As always, big shout out, big thanks to Jesse for continuing to support the show. Thank you, Jesse.
Thanks. So, Caroline, because our title sponsor is a taxidermist, a home-based taxidermist business in Kelowna, kind of like to do like a little taxidermy fact thing right after the ad roll. We've explored things with the Egyptians and all types of Darwin's expeditions and whatnot to do with taxidermy facts. So here's just a little question around taxidermy. So several decades ago, speaking of bans from the United States, the United States listed polar bears under its Marine Mammal Protection Act as an endangered species. So does that prevent U.S. hunters from hunting in Canada with Inuit hunters from taking their polar bear trophies back to the U.S.?
These questions are harder than I thought that I was going to be asked because I don't know the answer to that.
Okay, yeah, no, that's a pretty off the wall one, but it did actually that listing under the Marine Mammal Protection Act then almost instantly overnight prevented U.S. hunters from bringing a polar bear home to the United States. There were hunters who had hunted, they had left Canada. Their polar bears were in transit being looked after by the Inuit people and set up for shipping out, and they could never ship their polar bears back to the States to get done up by their taxidermists. So it had major repercussions on the income of a lot of Inuit communities because Inuit foreign hunting for polar bears is controlled by Inuit communities. They decide how many tags they will allocate to foreign hunters, or it could be none, could be all of them, could be some of them. But it was a lot of money. I think back in the early 1980s, it was somewhere in the terms of like about 40,000 US for a polar bear hunt. So probably six figures, now. So on the taxidermy side of things, there are taxidermists that actually create reproductions of a hunter's polar bear. They're completely synthetic. I saw some in Atlanta this winter. So if you want, you can go hunt and you get a replica. Like you've probably seen the fish on the West Coast, right? Like they're not the real fish. They're like same idea. I know it. Some hunters think, man, that's not my actual hunted polar bear. So I don't know if I would do that or not. So there you go. Taxidermy tip.
Fascinating. Yeah.
Caroline Elliott, thank you so much for coming on the show. Really look forward to chatting with you.
Yeah, happy to be here, and thank you for having me on.
So you are. This is. I love the backgrounds of people that have been on our show, and so you are a political commentator. You live in Vancouver, and you have a PhD specializing in Canadian liberal democracy.
I do. Yes. It's
amazing.
It really looks at the intersection of group-based rights and individual-based rights and where the clashes can be found, which that might sound more academic than most people would ever be interested in, but where the rubber hits the road is exactly what we're talking about today. So I'll expand on it as we go. But
no, that's awesome. Now you've been writing lots of articles in the BC and the national media about issues primarily in British Columbia that I've seen about the provincial park closures, some of the land transfers, around Haida Gwaii and stuff. So before we dig into it too much, like what has been your experience presenting these perspectives within the province and nationally? Like what are the pros and cons of what you've experienced by putting that voice out there?
Well, it can be lonely, especially at first when there's not crowds of people talking about this by any means. And a lot of people, I think, are deterred by the complexity of the issue because it is complicated. It's so complicated. And on the other side of it, there's a lot of fear about being perceived as someone who's kind of being dismissive of some of the real and valid concerns and challenges that many Indigenous communities face, and not wanting to talk about the issue in a way that suggests that you're dismissive of those concerns or challenges, and so it's a difficult line to walk sometimes, because what I've really tried to do in my commentary, and I hope I've done it successfully, is really direct what I feel should be legitimate anger on the part of the public on some of these issues, where that anger belongs. It doesn't belong with being directed at Indigenous groups. It belongs with being directed at the provincial government. You can look at some of these, some of the suggestions, policy proposals, negotiations, whatever that Indigenous groups are seeking. They're working hard on behalf of their communities, and that is their job. It's actually their duty as somebody who represents those communities to represent the best interests of their specific community, whether it's 300 people or 1,000 people or 5,000 people, however big it is, however widespread their public may be. That's their job, and that's what they're focusing on, rightly. The only level of government whose job it is to look out for the broader public interest of British Columbia, in my case, where I do most of my commentary, is the provincial government. That's their job. And when they're abdicating that duty, that's when we ought to start feeling some level of frustration where it's very valid. And so I think that's where I've tried to be quite careful about it. I do, I always feel, what's the word? Frustrated or unhappy to see some of the comments that will come out of some of the things I write, where people say, oh, and they'll say sort of things that are just totally, I couldn't repeat here, that are wrongly directed. And I always think, but for every one of those, there's a whole lot of people who are out there saying, yeah, you know what, I should talk to my MLA and I should be, advocating for continued access to the land. And that's what I really want to see on the other hand. So it's been interesting. I will say I experience a lot of support for the things that I write. I put out some videos explaining some of these issues in kind of plain language. And, I'll have people coming up to me at my kids' school saying, I saw your video and I really agree. And they may be whispering it, but they're saying it, and they're happy that someone's out there saying it. So it's been interesting. I don't regret any of it, but it can be,
comes with its challenges.
It comes with challenges for sure. Yeah.
Yeah. I mean, absolutely. And boy, it is complex. In Canada, we've got, Supreme Court decisions. We have the Constitution was amended and affirmed rights, and that was in 1982 or, or something like that. I did a podcast a couple of years ago. It was like the history of Métis people in Canada. And literally, I had to start the story 500 years ago in order to understand why Métis people are classified the way they are, different from First Nations. It's like the story literally starts before the Dominion existed. So these things are complicated. We've had Supreme Court decisions layered on top of Supreme Court decisions, both, the Supreme Court of Canada and for the various provinces. And it is complicated. And the thing I find about the Supreme Court decisions that are complicated is the courts kind of go like, the judge goes, here's my decision. And everybody's kind of like, okay, how do you put that into practice? And the judge is like, you figure it out. This is now law. Now and then it's years and years and years of governments and, and stuff trying to figure, what does that actually mean? Right. So it is challenging. So I think people, I agree, appreciate, when you're providing some education, like, hey, I understand a little bit more. Now, here's a question for you. This I'm sure you've thought about this, but I'm not sure if you've maybe ever had to articulate it. I don't want to put you on the spot here, but so these are challenging topics. The park closures that we've seen, Indigenous protected conservation areas, the land transfers, the land claims, the interest in being involved in the decision-making process, whether it's consent-based or joint decision-making. You'll probably talk about, that a little bit. So you've been talking a lot about the concerns of BC citizens, non-Indigenous people, about our government, sort of moving a lot of these things forward. So from the perspective of First Nations, and, one of the things I learned from Thomas King is you can't just say First Nations, generalize. You generally, because it's like everyone's different and has different views and perspectives. But if you did have to generalize a little bit, and you put yourself in their shoes, why are they asking for a lot of these things, do you think?
Well, I mean, not to put me on the spot or anything, but
No.
and I hesitate to speak in any, suggest even
Yeah.
that I'm speaking for them,
because what's your understanding of
yeah.
their arguments, I guess. So
Yeah. No, that's a good way of asking it. Look, I think it comes back to ultimately the meaning of the word reconciliation and the way that it's been used in some of these legal judgments, and it's kind of reconciling the pre-existence of Indigenous societies with the sovereignty of the Crown. And I think that's it. It is a very tricky thing. For them, they're gonna, as I've said before, they're gonna make the claims that they need to make to get to the place where they think that they can. Going back to Thomas King, getting back to the place where, sovereign ultimately comes down to a question of land, right? And so my sense of the argument is that based on a connection to the land for generations and generations going back, preserving that from all the different pressures that are there as well, right? Whether it's the natural resource sector or hunting or recreational use or whatever it is, it's kind of trying to set up those boundaries to ensure that the integrity of what they understand that they're owed or should maintain sovereignty over is protected. There is some differences though, like across Canada. You touched on this very briefly. BC is largely untreated land. So if I was going to ask this question, if you were to ask me this question in relation specifically to, let's say, Treaty 8 in BC's Northeast and some other parts of Canada as well, I might say my understanding is, look, they are trying to protect what they were promised, which is the rights to hunt and trap and fish and so on, and exercise their way of life. And they've done that, through the courts and things. You mentioned Yehi. Whereas other parts of British Columbia, it's a little bit different of a question because there aren't those treaties there. So they may be looking to find, to ensure that they're protecting their ability to have title recognized to certain lands, for example. So I think it maybe depends a little bit on the context.
Yeah, definitely. Because, I think, is it the Musqueam? They have a land, like they have a treaty, a modern treaty. That's one of BC's modern treaties, and a land settlement.
Tsawwassen?
Around Tsawwassen. Yeah.
Yeah, it's a Tsawwassen First Nation, yeah.
The Tsawwassen First Nation. Okay. Yeah. And their interests were land development, housing, the economic aspect of being in real estate, where you go to the far north and the interests are land to hunt and fish and trap and to kind of be away from all that sort of stuff. And then when that's encroached upon by, seismic lines and, and all sorts of, I think I read in the Yehi decision, the Blueberry River First Nations, that it was like 80% of the Blueberry River First Nations territory, no matter where you stood, you were within 7 meters of some sort of man-made structure. A logging road, a mining high road, a seismic line, a well pad, a clear cut, something so that was the whole issue of cumulative impacts, which, kind of bubbled up to Chief Yehi taking the province to court. But yeah, It's challenging, and that's, I think I've said before, I tell people, like, try to develop relationships with your local First Nations to understand, rather than generalize across 200 and some nations in the province. And maybe that's part of the complexity of the conversations, is it's so different everywhere you go in BC.
But and I think it's interesting because it's in so many, like, I'm probably going to keep coming back to this comment all the time, but really about finding the balance, right? Where, maybe in the example you just cited, and it's not the balance just between Indigenous and non-Indigenous, it's a balance between all the different interests in the land, whether it's the natural resource sector that benefits our economy, which benefits us, or whether it's, hunting and trapping and fishing and those kinds of activities, whether it's recreation, like these are all demands on the same finite area that the province and the federal government to some extent are tasked with balancing out, depending on what the issue is, right? And figuring that out. And what the courts have consistently, like through all the decisions that there have been on since 1982, with the Section 35 recognizing Aboriginal rights, they've always called for a balancing of the public interest with the unique interests of individual Indigenous groups. And finding that balance, I think it's a very difficult task, but it is ultimately the task of the governments we elect, right? It's working through those things piece by piece and finding, I think right now the balance has gone one way that's not going to be sustainable in terms of having a harmonious society that works in the long term. But I think balance is a critical component of every part of this conversation.
Yeah. Now, I guess you could argue that the balance would be, there's nations that want sovereignty. They want to make their own decisions. The Nijika people have their own school system. They have their own legislature. They have their own elected officials. Had the pleasure of actually sitting in their legislature at the sitting of the House one time. It was very much like ours, other than they have a little different layer in their legislative system than ours. They tried to mirror it with the provinces. They have a council of elders, which would be kind of like a senate at a smaller level. So one of the elders was actually there at each sitting of the House, and he had to hear everything on behalf of the council of elders. So they have self-government, and they have an area of land in order. Like, these are our boundaries and we do our thing, inside these boundaries. It's not overly large, in the whole terms of the area of the province. So one of the arguments could be, like, does non-Indigenous people need every square foot of BC to have access? Or can there be a portion that become, Indigenous lands only for access, hunting, fishing, development, that sort of things? Can the people of BC say, yeah, like, a little bit's okay, but not the whole province? Like, what's your read on people out there over the scale issue, I guess, boils down to?
I think it's look, I think my view is, when you come up against an issue that's this complex and there's so many moving pieces and so many interests at stake, I believe you have to get back to first principles. And when you stray from them, I think you can end up in really difficult places. So, and this doesn't directly answer your question, but I hope I'm going to get to my answer and not forget to follow up on that component of it. But I think, sorry, my ringer's on here. So first principles, like, look, decision-making over land, for example, or transfers of land, for example, I think you can end up in a very tricky place really, really quickly. You have a province that is essentially, in terms of traditional territory claims, it's over 100% of this province is claimed, right? We have, I believe, 1/3 approximately of Canada's Indigenous groups all in BC alone. So there's about 600 plus Indigenous groups across Canada. just over 200 of them are located in BC. So you start having these situations where you say, and we talked about this at the beginning actually, is like, look, like the Indigenous groups aren't one big monolith. There's 200 of them and they're different from each other and distinct and deserve that recognition as distinct groups. But when you have those 200 groups making their claims around various pieces of land, you end up in a pretty expansive, potentially, understanding of what those rights, let's say decision-making rights, are over that land, or their Indigenous access only to various land. I do think that you end up in a tricky place from a first principles perspective when you do have, frankly, ethnicity-based access to land as a rule, as an accepted law, because I don't know that there's a society in the world where you can point to, in the long term, that kind of ethnicity-based rules working out really well in a harmonious way. I just don't think that you do. So, and I don't want to, I'm not catastrophizing. I don't think that we're going to become, South Africa or anything. And people do draw that connection sometimes. That's not what I'm trying to suggest. I just think that you end up in a very difficult place very quickly if you stray. So I think that has to be in the back of the mind about all of these things. I think, look at some of the individual things that are happening right now, like the Seashell Foundation Agreement on the Sunshine Coast, which I think is probably maybe the pointy head of the spear in terms of where everything's going. Like, I think it's right on the forefront of what this could look like in BC broadly. It gives varying degrees of decision-making power over 1.2 million acres of public land, to an Indigenous government representing something like 1,700 people, I believe. So under that agreement, all new and replacement applications for any Land Act decision will now go through either a consent-based, or an exclusive decision-making process. So shared, in the shared model of decision-making, the ultimate authority rests with the province. But the Seashell are a very strong stakeholder in that process. So, okay, that's can be more defensible from a democratic perspective. But when you get to the consent-based decision-making, you really do end up in a place where, both the province and the First Nation must approve an authorization before it can be issued. Those are the government's words. So if that's not a veto, I really don't know what is. And it's so interesting because federally, they're acting and saying, look, like sorry, I'm jumping all over the place, but the federal minister recently said, Sean Fraser recently said something about UNDRIP and the federal act implementing it or aligning federal laws with it did not amount to a veto. And he got in a little bit of hot water about that. And Indigenous people were saying, stop focusing on this. It's not very productive. It's not a great way to start your role, whatever. That's maybe a fair criticism. That's not the first thing you want to say in that new role. But I think the federal government, they are showing some level of understanding, potentially, that it is not a veto and shouldn't be interpreted as such. In BC, it's very different. They are moving ahead with consent-based decision-making agreements, which mean that if there's a project in the public interest, or not necessarily a project, a policy, whatever it is, an authorization that the province really wants to give because the vast majority of the population is going to benefit, they cannot issue that authorization without the Seychelles' consent. And again, that's in their own words. Then the agreement goes even further with a commitment to explore exclusive decision-making. And in their words, it says this would recognize the jurisdiction of Seychelles to make decisions in relation to specified matters. They haven't said what the matters are, with the province stepping back from decision-making on those matters. Again, this is not reserve land. This is public land that belongs to hikers, hunters, mountain bikers, you name it. So it's worth looking at an example of this just in real time that's rolling out around the Seashell Foundation Agreement on BC's Sunshine Coast. So there you have varying degrees of decision-making power over 1.2 million acres of public land, not reserve land, but public land, being given to an Indigenous government representing about something, I do think it's around 1,700 people or so. Now, under that agreement, any replacement application for a Land Act decision will now go through this decision-making process. Now, decision-making might be shared, where the authority rests with the province. Decision-making might be consent-based, where both the province and the Sechelt Nation have to agree to an authorization before it can be granted. Or there's even a provision in there for exclusive decision-making. But I want to talk about the consent-based one first, because it's more common and it's popping up in a lot of agreements. So these consent-based agreement arrangements provided for in the Sechelt Agreement basically require, in the provincial government's own words, that both a province and a First Nation must approve an authorization before it can be issued. So something, that authorization, whatever it is for, may be in the public interest for the benefit of all people on the Sunshine Coast or even BC. That will not be granted unless the Sechelt Nation agrees with that. The issue with that is it comes up against the democratic requirement that you and I, Indigenous people, non-Indigenous people, the basic democratic requirement is that we all have a say in the decisions that we're required to live by. And the way we have that say is we elect our decision makers who make decisions for us, and we can either reward or punish them at the ballot box come election time. It is kind of the basic way that we make sure that decisions are made in a democratic way. Now, when you take that decision making and effectively give it to a group representing 1,700 people that non-Indigenous British Columbians can't vote for, in fact, no one but those 1,700 people can vote for, even though they affect a much larger segment of the population, you're in a place where that decision making is no longer actually democratic. And to go to the exclusive decision making model is even more of a radical thing. So what the province is saying there, and you know, I don't want to, you know, make this seem like it's being kind of exclusive decision making writ large, but they're talking about finding an issue where they will allow for exclusive decision making for the Sechelt Nation. Maybe it will be on the hunting, numbers, the harvest numbers. Maybe it'll be on access to cultural sites. Like, I don't know what it would be on, and I don't want to speculate too much. But what will happen there, in the province's own words, is that the province will step back from decision making altogether on those matters. So there you have a situation that's, in my opinion, considering it's public land that belongs to all British Columbians, it is fundamentally undemocratic. So, to kind of go back to the point about first principles, whether it's access to land, decision-making over land, we have to really stick to those principles, in my opinion, where that access is granted. If it's public land that belongs to all British Columbians, it is granted to all British Columbians. If a decision is to be made democratically, that decision needs to actually be democratic in terms of the processes by which it's made. So some of these tougher questions, I think, are best kind of brought back into those first principles questions to kind of keep us aligned on an issue that is so complicated that I think there's a temptation to say, oh, what's the harm in this one case? What's the harm in that one case? When really what you're doing is kind of is allowing us to go in a direction that's not going to work in the long term.
Right. Now, just kind of a terminology thing, but the way I was to understand the agreements, decision-making agreements under BC's DRIPA Act, was there could be an agreement for consent-based decision-making or joint decision-making. So I don't know if the language has changed. Currently, sort of before DRIPA, because of the Haida decision, governments were obligated to consult with First Nations. So prior to that, governments used to just do whatever they wanted to and didn't talk to Indigenous people at all. Then the court said, no, because of the Constitution, you have to consult with them because they have treaty rights and constitutional rights. You have to consult with them. Consulting legally, as I understood it, only meant you just have to tell them what you're planning to do. If they disagree with it, the province could still go ahead and make the decision. But they would have some legal requirements to compensate or, mitigate the impacts to rights or title. Then under the DRIPA Act, I thought consent was more like a higher level of consultation. There was no decision making there. It was just they had to have what the UN says is the free, prior, and informed assent. So basically, they have to agree. Even if there's going to be impacts to rights and title, they have to be able to demonstrate we freely made this decision on behalf of our people. We had all the information at hand. Nothing was being held back from us. And yeah, okay, you can go ahead and develop that mine or put the waste rock pile over there or whatever. Or they could say, we don't like any of the way that you're going against it. And that would be what you're saying is the no-go on the decision.
Yeah,
So,
and I think. Oh, sorry. Yeah.
I don't know if free and prior informed consent has actually been tested in the courts to say, does that mean 100% yes or 100% no, or can the province still go ahead if there's objection to a decision?
There was a court case around it, and it talks about it essentially amounting. I don't want to misquote this, and I'm also I should say, I am not a lawyer. I'm not a legal scholar. I'm a democratic theory scholar. So I can talk about democracy till the cows come home. But so I don't want to make myself sound dumb by trying to describe something that I'm not an actual expert in. But there has been one court decision around this. I'm missing the name right now, but it's at the tip of my tongue. I'll leave it. Point is, it actually what the free, prior, and informed consent provision in UNDRIP was understood as in that case is a very robust consultation. There is no this is where it gets really tricky to talk about. There is actually no requirement no legal requirement for consent understood as a veto. But I do think different governments are acting on DRIPA in different ways. So the federal government, had their minister Sean Fraser come out and say that a veto or UNDRIP does not provide for a veto. It's more about robust consultation, and some Indigenous groups took issue with that. But it did give a sort of insight into where the federal government is going with this, which I think is an accurate understanding of what it means, probably legally, without again being a legal scholar. But in BC, what's happening is the government is proceeding with DRIPA as though with their Declaration on the Rights of Indigenous Peoples Act, I should step back for a second, which implements UNDRIP, requires that BC's laws be brought into alignment with UNDRIP is actually the proper way of describing it. I think many think that the province is understanding that requirement differently than the federal government is, in the sense that they are providing for these consent-based agreements that go far beyond robust consultation and go into this authorization will not be issued without the consent, without the agreement of that Indigenous group. And that's where you start to run into rocky territory with those basic democratic requirements. Yeah, so I hope I'm not getting too convoluted there. But I should say, in Canadian, we were going back to sort of what the Canadian law has been in this regard, just generally. And prior to DRIPA, it was, consultation is under the Constitution Act. Consultation is required where appropriate. Accommodation might be afforded. And where there's treaty rights, for example, Treaty 8 territory. I worked on the Site C Dam actually for a while, so that's why I talk about Treaty 8 a lot. So that's where it was located. But when there are infringements of various rights, the province is able to argue that they're justifiable in the broader public interest. For example, hydroelectricity powering the lights that we turn on in our homes. So that's where the law kind of was then. What BC is doing is going far beyond those requirements in the Canadian legal context so far, way beyond. There is no legal basis in Canadian law for exclusive Indigenous decision-making over public lands as they're contemplating in the Sechelt Foundation Agreement. So the consent-based, the joint authority that they keep referring to in some of these agreements does not actually exist over public lands. The province is the authority over public land decisions in this province.
Now, I do know of one agreement between the province and the Tahltan people of Northwest, and it is a joint decision-making process, but only under the Mines Act, Mineral Tenure Act. So it has, and not under the Wildlife Act, nothing else. And so, because mining projects and the Golden Triangles in the in Tahltan territory, they have an interest in mining. They're not against it. The Tahltan government is actually a co-owner of the Red Chris mine, and they wanted to be involved because it was a concern of their people, the impacts of mining on the land. They, as I understood it, was the first joint decision-making process that was agreed to by the province of BC. And the way I would understand that is it would be like this equal review process of the mining project until everybody reached a point how the mine was going to be developed, acceptable impacts, and then the province would sign off on a permit and the Tahltan would sign off. Potentially, the mining company would end up with 2 permits issued by 2 governments, or a single permit would be signed off by 2 government decision makers. And I don't know if that's, from what I've seen, I haven't seen anything that I would say would be a negative impact to the public over that. They actually kicked the jade miners out of Tahltan country, which were kind of a fly-by-night mining operation that the province was sort of turning a blind eye to, and the Tahltan government kicked them out. And then they also made an agreement with the mining companies had mineral claims over the Mount Edziza area that they wanted left for cultural reasons, and the province, the mining company, and the Tahltan all came to an agreement and created a no development zone. And maybe that's one of the things where it doesn't exclude people from from using the public land. It's just that there will be no mining in that area. And I would say some of those things, people see that as a win, rather than mining development in somewhere. It's like everybody kind of wins. There's some wilderness that's protected. But that's a case study with the Tahltan just to do with mining, where, other than just the mine properties themselves, like the public hasn't been excluded, so to speak, from using anywhere of Crown land. So do you think it's the uncertainty around like the seashell example that you gave, where people are like, well, what's this going to involve? What does that actually mean? Because that's what I see in Manitoba. And the Manitoba Wildlife Federation is saying, well, what's this actually going to look like? Like, we kind of want to be privy to these conversations.
Yeah, I think a lot of these decisions sound good, and it's so often the question of what's the harm with a lot of this. What's the harm, right? It's one group and it's an important area, and it's, the issue is with the Tahltan example, like a joint decision-making process, it doesn't necessarily have to be an undemocratic process if the province is the ultimate decision maker. But if that agreement's requirement is that you require the agreement of both the provincial government and an Indigenous group in an area that is critical to the province's mining industry that affects the 5 million inhabitants of BC, sometimes there may be, it's all fine if everyone can get to agreements and everyone can just sign away on the authorizations and make it happen. But inevitably, there will be cases where you maybe don't have that that kind of perfect situation, and there are fundamental disagreements. And how does that actually play out? And it's often not clear. And so I think a lack of clarity is part of the problem. I think the devil's always going to be in the details. It's always going to be in every single mine operation that wants to go forward. Does it get to go forward? Who made that call? And what was the basis of that call? That's going to be where you get into these more difficult, potentially, situations. Like, I know the province, I know the province announced at the beginning of June the joint land use planning process with Indigenous groups in the Northwest. It's 40 million acres, so it's an area larger than England. So massive amount of territory. And they talk about consent-based agreements as part of that land use planning process with these 5 Indigenous groups. And I think they amount to something like 15,000 people, these 5 groups combined. And if you're going to have consent-based decision-making over an area the size of England, made by governments where the vast majority of the British Columbian public has no accountability relationship, no democratic relationship with the decision-making bodies, you have a real problem. And if that's the template for the Northwest, then what's the template for other parts of the province, right? So that's where I just think there's more questions than answers, but the questions I'm seeing are concerning ones.
Yeah. Now, again, not a lawyer, but so a lot of the foundational rights, whether they're title or rights or, interpretations of what was in old treaties, an interpretation, how does that unfold in a modern context? Like I know, as an example, under the Yehi decision, the judge was like, yes, the Treaty 8 said they have a right to hunt and use the land. But my interpretation is they have to have somewhere to hunt in order for that treaty obligation to be fulfilled. You can't completely slice up the landscape with industrial development and say, well, you can go hunt, it's like so the judge kind of modernized the interpretation of Treaty 8, a little bit there. I think the Northwest one, unless I'm wrong, I think is going to revolve a lot around caribou management and the cultural significance of caribou in the Northwest, and kind of, a lot of the herds are on the decline. They're looking for this larger collaborative project around caribou management. And it's interesting because doesn't the province have to willingly choose to enter into an agreement? It's not obligated to have a shared decision-making process. It would have to agree to enter into a shared decision-making process. It's not being forced on the government, so to speak.
Yeah, I think that I guess the question is, does the province have the right to abdicate its decision-making role when its duty is to all British Columbians in such cases? And I think that I don't want to mischaracterize it, but I think that that's part of the challenge that that one community group on the Sunshine Coast is bringing forward. They have a constitutional challenge against the province's DRIPA, Declaration on the Rights of Indigenous People Act. In the group that's doing it is the Pender Harbor Area Residents Association, FARA. They're doing actually some interesting work in challenging the government. It's the first challenge that I've seen in BC against it. So it'll be a very, very interesting case if it all goes forward. But I think that that's kind of what their concern is that the province is not living up to its duties to the public in coming to these kinds of agreements.
Right. Okay. Yeah, I mean, as a citizen of the province too, one of the things I look at is, like I said, foundationally, a lot of the things that might be part of a shared decision-making process are already rights, whether they're constitutional or treaty rights. If the province doesn't do a good job, like say in engaging a nation on a mining project approval, and the nation's like, look, you didn't listen to us, you didn't take our concerns in to see you in court, then a judge gets to decide. And then there's no public process over there other than the will of one person making legal interpretations. And as I understood it, the Silkatine case that I was talking about, the 1,700 square kilometers of land, was a court case, and the judge just went, well, I'm going to fix this, bang. Province, you are legally obligated to give the Silkatine people all this land. End of story. No, the province was freaking out about it as well, like the government, because, there's mining investment insecurities and all that kind of stuff when a court does that. So could DRIPA and the process of shared decision-making or consent decision-making potentially be a tool that's better than leaving some of the differences up to a judge?
Well, you're touching on like one of the like great conversations in Canadian democratic political science, which is the
Okay.
sort of the question between where do you want decisions actually ultimately made? There's a lot of concerns with judicial activism, for example, versus democratically elected legislatures, and who's the best guardian of the public interest, who's the best guardian of minority interests, and there's this whole kind of conversation about post-charter, especially it's post-1982, especially around kind of where, has the judiciary effectively become policymakers more than they should be? And, that's a whole other question that we're not going to fix because none of us are going to, have the power to change the Constitution. So I think working within our constitutional context has to be obviously what we do. And look, like there's, I think, the province has an obligation, I think, in the courts to put forward what they think is the best argument in the public interest, however they interpret that. And the judge will ultimately decide when it goes to that. Yes, I do think that there are real benefits to resolving as much of this outside of the courts as we can. Like, it doesn't serve anybody well to have a kind of really conflict-based approach, to resolving this. Like, let's just fight it out in court until it's all settled is kind of crazy too. So I think that there is something to be said for sort of a proactive approach to this. The problem is working with Indigenous groups to try to find the right path forward. I think that the way that they're doing it now is not the way to do it.
Okay. Yeah, I mean, it's definitely, our read on the situation too is there's a lot of, citizens are very worried about that process because, obviously when it comes to people's private land and their homes and, just kind of what's unfolding on Haida Gwaii, it's people's homes and stuff. They're wondering, yeah, and that happened initially. People are like, well, is private land going to be part of the transfer of Haida Gwaii? And what about like the highway system and the ferries? And, there was a lot of uncertainty and unrest, around that. Is there a better model where the public is more involved in the conversations that go with all of these land decisions? Because I think that's the Manitoba Wildlife Federation's case, is they're saying like great, you want reconciliation, find some balance with, how much or where the Indigenous communities in the north want to hunt moose and not have Indigenous or non-Indigenous hunters around. But it's like somehow that process has to be more open and transparent so we can all be part of that. Do you see a balance there where more of these discussions are in the open? Because it is a lot of it's government to government conversations that are confidential, and agreements are made, for better use of the word, behind closed doors. Like, would it help if the public, it was televised, like our legislature, you get the one side says this and the one side says that, and all Canadians get to watch who's saying what? Like, would that be better?
It's like the absolute bare minimum, and even then, it doesn't get close to kind of getting to the root of the problem. But the lack of transparency has been absolutely horrendous.
Okay.
That there was a big issue in the Northeast, I think, like maybe a couple of years ago, around the Blueberry River case, where people felt really, really shut out, and no one would talk, and all the interest groups were not involved in the conversation. It was like a real issue. Look at the Land Act amendments that the BC government tried to push through last year with just absolute minimal. Like, I think that they posted a consultation page and not like actually released it. Like, you know what I mean? Like, pushed it out. So it's like, if you don't know it's there, no one's going to comment. That kind of, and I don't know if I have that quite right. It's a year. It's is it 1 or 2 years ago now? A year ago.
2. Yeah.
Yeah. God, it's summer and I'm losing my grasp on the dates. But my point is, like, they were very, very secretive around that. And I think that that's one of the things that the public rightly really reacted to. And I think that that's been a hallmark of their approach. You have now you have, for example, with the Joffrey Lakes provincial park closure, which I was, I had something to say about that recently. You see longer and longer closures in these cases without apparently any consultation with the public whatsoever in terms of what those closures are going to be. I think it was in 2023, it was 39 days closed to the public. Only Indigenous groups from the area could go. 2024, access was restricted for 60 days. This year, the groups announced that it will be more than 100 days. And then the province comes out and says, well, it's not, we haven't actually finalized the dates. But yet they're enforcing the closure by having their conservation service there, turning people away. And then they come out with a press release saying, okay, well, we've agreed kind of on some of the closures. We don't know what the fall ones are, but here's how it's going to be open for the summer. And then they say it's about environmental restoration. And it's like, but we all know that it's not about that. And you need to, it's not the reason the province is closing the park, right? They're closing the park because the Indigenous group asked them to. And there may be, it is frankly an overused park. There's too many people that use it. Everyone's obsessed with it for social media. Like it's like the antithesis of what you go into the wilderness for, right? I think there's real merit to reducing numbers, but
the tour runs of Yellowstone.
But there are ways of reducing usage that aren't restricting it to everybody except for the Indigenous group without telling the public that that's what's actually happening.
Yeah, because that one's interesting because I've talked to like a few non-Indigenous people that live in BC, and they're like, I get it. Like I've been there, and that park is a mess. There's trash. They've had grad parties up there. As far as you want to go in on the trail systems, there's just stuff, all over the place. So I can kind of. The people said I can empathize why a nation wants to shut it down to, quell that. But I guess what you're saying is the government's not really saying why they're agreeing to the closures. If it was a misuse thing, then BC Parks have to come in and say we need to implement a parks pass, a booking system, a trail booking like the West Coast Trail is like that, right?
And
because this is what you're all doing, and now we gotta penalize you over that. But that's not what's happened.
Yeah. Well, and they did introduce a reservation process, which then all got messed up when the nation unilaterally closed the park, and all these reservation holders showed up and couldn't actually get into the park that they had actually gotten a pass for. So the problem is, look, in that case, overuse, yes, the reason I hike is to get away from people. So I wouldn't, that's not my scene, and it's not a lot of people's scene. But look, okay, if they were giving 1,500 passes a day, give 200 passes a day. If 200 is too many, do 100 too many, do 100 passes. But I don't think that you can have provincial parks being shut down to people on the basis of ancestry. I just don't. It's a non-starter for me. So if it's, it's Joffrey Lakes now, and yes, it is overused and all the things that we just talked about, but is it Garibaldi? Is it Manning Park? What's the next one, right? And it's happening with federal parks as well. So on the island in particular. So this is where I think you end up in the slippery slope kind of, and I hate using words like that, but you do end up in a slippery slope where, an Indigenous group might quite rightly say, you know what? I really like using, Banff National Park, and it is part of our traditional territory. And actually, I'd like to do what they're doing over in BC in Pacific Rim National Park, right? And it's like, what precedent are you setting, and how is this actually gonna work in the long term?
Yeah, it's interesting when you kind of go back to say your message is aimed at how the government is handling this and not being, transparent and open with the voting public, the citizens on this. And boy, I've been following all these complicated stories, I was saying, for the last 7 years, whether it's the Alver fishery or whatever. And it all seems to come down to that very same thread. It's our governments, provincial and territorial and federal, that just seem to kind of bungle these processes of reconciliation with First Nations, whether it's resource use, whether it's land settlements. It's just like the Nisga'a Treaty in BC, one of the last modern treaties that was signed kind of in the 1990s, took 110 years or 107 years of negotiations to settle that treaty. And, if I were to look at my elected government going like, that's got inefficiencies written all over it, like to drag something out for that long. It comes back I think a lot, and I've heard that from First Nations as well. It's sort of like, it's not you we're upset with, it's your government, right? Because they're not listening or they don't understand what we're trying to get at here. And after the Yehi decision, there was a really great example of this. And there was a First Nation in northern BC that was sitting with some of the hunting organizations, BC Wildlife Federation, at the table. And they said, one of our concerns is there's this area over here. And every year in the fall, we like to put up the cultural camps. We get the kids out on the land and we moose hunt from there. But we have all these people from rolling in with their trailers and side-by-sides and stuff, like, well, we're trying to, and it's like, can we just set this side away as a no hunting area for 2 weeks every year at the beginning of October? And what I was told, people that were at the table were sort of like, yeah, that we can work with. This NGO group and this First Nations, yeah, we can sit down and we can figure that out. The province got involved and said, well, we're going to reduce moose permits for the whole entire northeast corner of the province by 50%. And people were like, big overreaction, right? Like, it's just sort of, it's almost like I'm kind of thinking, if you kind of let people work with the Indigenous communities and fix some of these problems, if the government stayed out of it, we would probably have way better results. But I don't know how you could do that other than just citizens to nation discussions where you both agree to cut the government out, which I think worries them, because then they're like out of a job, right? If the citizens cut them out of the picture.
Well, I do think I agree with you. Like, I do think there's goodwill on both sides and a willingness to kind of figure out, like, even between different users of the land just altogether, like, there's always some compromise that you can probably reach coming to the table and having a conversation. And I also agree that government sometimes is like the least productive, if not counterproductive, to like a good conversation, because they get people's backs up, right? And people start thinking, oh man, okay, like suddenly, I can't go back to moose hunting with my dad the way I always did, or whatever the thing is that's important to you, right? And that's where I think you do, like, this is what worries me about the entire approach, is I think we are heading towards, if things don't change, resentment and division. And instead of kind of an inclusive approach that pulls all the interests together at the table and tries to foster a conversation aimed at some mutually beneficial outcomes. And I just don't think that government's really been facilitating that. If anything, they've been kind of worrying people to the point that they're now suspicious of everything that government announces.
Right.
Yeah.
Do you think when it comes to things like, Haida Gwaii, the transfer of land ownership there in Manitoba, they're talking like similar things. I think the Seal River Indigenous Protected Conservation Area is 6% of the entire province of Manitoba. Like, on a scale, it dwarfs like the Haida Gwaii land transfer. Probably not if you were a non-Indigenous person who lived and worked on the island. It would be a pretty significant thing. But do you think there should be some legislative thresholds in the province where something like that it's like beyond the scope of an elected government to be able to make that decision regardless? Basically, it was like, do we need a legislative mechanism in the province to say something beyond an elected government has to take place? Referendum, whatever you want to call it, when it's a land transfer for exclusive rights and uses that's over a certain size.
I think that would be honestly, a good starting point is to say, look, like we are going to go to the public if we're going to talk about significant land transfers, if we're going to talk about significant changes in the way decisions are made. It's what, like, that's what our, constitutional amendments require supermajorities, and they require, a certain number of provinces, for example, voting with a certain threshold in their legislatures to make it. That's why constitutional changes federally never happen, or rarely happen. But so, yeah, you could do something that is a little bit extra to give the public faith that their interests are really being looked after. I wish it didn't actually have to come to that, though, because the province should just be looking out for the public interest. There's in terms of all British Columbians, whether they're Indigenous, whether they're non-Indigenous, it's about looking out for the broader public interest of the province. That is the province's job. It's what they should be doing. And the fact that we're even talking about something beyond them to make these kinds of decisions shows, I think, how they're actually not really doing that at this point. And Haida Gwaii is a good example of that, where you have people significantly impacted, and people will downplay the private land impacts, and they say, "Oh, we've protected it in the agreement," but people forget that Indigenous rights are protected in the Constitution and private property rights are not. So when push comes to shove in some of these when ultimately there are disagreements, how's that ultimately going to get decided? And I think that we probably have a pretty good sense. So it's always the details in these agreements. Things sound really nice, joint land use planning, and consent-based agreements, and title over Haida Gwaii, whatever the issue is, it sounds nice, and it's so hard to combat because of that. But it's when people understand what it means for their democratic rights, or for their their equal citizenship, or whatever it is, that people start kind of thinking, okay, well, how is this actually going to roll out in those detailed ways when it affects me?
Right. Yeah. No. I it's a lot of what what I hear as well is that it's the what ifs, the details, the questions that people want more information on, more definition before they say I'm for it or I'm against what's going on. It's just purely keeping people informed. And I think that's what Indigenous people have been saying for a long time. It's like, we haven't been fully informed of these decisions,
Mm-hmm.
so we want to know more, so we can make decisions ahead of their time. I don't know what it is about governments withholding information from the masses, regardless of who you are. Why that's even a thing for a democratic government is a little weird. I guess one of the last kind of questions to wrap it up. So you've probably come across this. So there's this bigger thing out there in the universe that BC and Canada is moving this way with Indigenous protected areas, with sovereignty, with land transfers, with decision making, because it's moving towards this grand idea of the United Nations, of sort of this world government, and getting powers away from average citizens, away from state governments. And it's buying into this world government thing, of which the United Nations, some people think that's why they were created, is for this single world order. And I was just reading that even today, that they were saying, like, yeah, that's what DRIPA was about, was this mechanism for states to transfer and recognize these rights, where it allows the United Nations to have more power at a global scale, because the state has lost its authority within its own sovereign boundaries. Like, it's conspiracy, it's tinfoil hat kind of stuff, I think, but have you come across that? Like, what are your thoughts about, like, the motive beyond just the province of BC type
Well,
stuff around this?
I have come across it. It gets brought up in some of the replies I get to some of the things I post, or some of the articles I write. Look, like I've worked with the provincial government at one point in my life, and I don't believe them competent enough to be implementing a world conspiracy. Like I just,
Okay.
that's
Okay.
my theory about most conspiracy theories is it requires way too much coordination and way too much
Yeah.
competence. And so I don't really think that that's at the root of this, but I do think that, I definitely think that there is what's happening in BC is a microcosm that could well play out in Canada at least.
And we are seeing that, like in several areas. Like I keep bringing up the Manitoba, case. I think I just read a story a week or so ago about in Nunavut. There was some additional areas that Inuit people are looking at having designated as Inuit traditional use areas only. So the mining exploration companies would not be allowed there. Other hunters wouldn't be allowed there, land users or trappers. So it is happening. It's definitely a national conversation, not just a BC conversation. I don't see too much happening up in the Yukon, but they'll probably eventually start seeing more of what maybe is happening in BC. I have connections up there that says that the Yukon government is very much like the BC government when it comes to these types of conversations with its Indigenous communities and decision making. So it's got them a bit concerned about the future of public lands in the Yukon. Oh man, it is complicated, isn't it? It's and I can probably appreciate some of the comments you get on social media because these are really hard conversations to have, and not somehow come across one way when you're not, or have people say, well, you're this or you're that, or you're not taking into consideration. I always feel a little bit handicapped or uneasy that we don't have an Indigenous voice saying here, going like, well, look, this is really what our nation is trying to do. Whether or not like that would work in a forum like this or just separately, I'm always open to have that happening. It's a little more challenging to get Indigenous leaders on the show because they're just like busy people and beyond what you can imagine. Actually, some of them that I do know what they're dealing with. And so that's kind of hard as well. Their focus is on engaging with the government because that's where decisions are made and not necessarily having these conversations just sort of in the public purview. So I always worry about that a little bit. Like I don't want to come us across where we're just talking, just purely from the non-Indigenous side and not understanding their side. We do, try our best to do that as well. And, lastly, I think I heard this from an Indigenous lady that taught at the college, in the town that we're in, that sometimes she said, like, it's up to you folks, the non-Indigenous folks, to have these conversations amongst yourselves and figure some of this stuff out. Because it is kind of getting tiring, like telling you our story and educating. So I taken that to heart a little bit, and it's given me a little bit of comfort that we can have these conversations amongst ourselves because we're trying to figure out what all of this stuff means without always having to, say, hey, can you tell us? We're having the conversations trying to figure it out. So hopefully Indigenous people kind of appreciate that we're muddling our way through some of these complex conversations, trying to sort it out the best we can as well. So any kind of final thoughts, Caroline, like something that we missed?
I think I think you're getting to exactly where I would get, is that, more often than not, if you have a conversation, I think there's so many aligned interests around conservation, protecting our lands, making sure that things are there for the next generation and the one after that. These are all things that the interests I think that Indigenous and non-Indigenous people share. And I hope it doesn't have to be like an either or conversation all the time. And I hope we can get to that point. and sometimes, and this is why maybe I started off where I'll end, which is when we feel frustrated about some of this stuff, it is so important that we remember where to direct that frustration and keep it focused on the levels of government that we elect that are supposed to be doing, I think, a better job of holding those conversations and making that space for that dialogue and balancing the different interests when they do not align. So I think that's hopefully where we can get. It's not a very prescriptive approach, but I hope we can kind of get there at some point.
Right. So if it were up to you tomorrow, what would you put the brakes on in BC, and what would you get people headed down a different path?
Well, look, like what would I put the brakes on? I would put the brakes on consent-based decision making, and I would put the brakes on ancestry-based access to public land. For me, those are non-starters. But what I would want to see more of is, I do think the sentiment around some of the more inclusive land use planning with everyone at the table to look at kind of what the demands are, what the different interests are. I think that's a good approach. Like if you look at not the way they're doing it, but if you look at the websites they've developed, they've kind of mapped out like the different areas, who they're talking to, what the different interests are, whether it's, natural resources, like whether it's mining or hydroelectricity, or not just that, hunting and recreation, you name it, like trying to pull those interests together and actually like figure out what the future of land use planning in the province looks like is great. It just has to be inclusive of all the stakeholders.
Yeah, no, I agree. And I think, so many people I've talked to basically echo that same thing. And we see a very collaborative example of that in Tahltan territory in Northwest BC. Our good friend Mateen Hassimi is a big part of that, working with Tahltan government, but it's around caribou management and the future of the sustainability of the caribou populations in Northwest BC. And they have a multi-stakeholder table where traditional knowledge, Indigenous views and values, with scientists that do Western science and put GPS collars on caribou and fly in helicopters, and guide outfitters who are saying, this is what we're seeing on the land. They're all literally like in the same room with maps and pens, and they're drawing and planning things out and charting a path forward. I do believe that there is a much stronger non-government leadership to that process. Government is at the table, but they're not steering the table. And so what I'm seeing from the work that Mateen is doing up there is they're getting way more done, way more collaboration, more reconciliation of saying like, everybody wants caribou on the landscape, and Tahltan want it, and they also want the outfitters to be able to operate in their traditional territory. Like it's a really good example, I think, that that is exactly what you're talking to about, but just putting the brakes on some of the liberties maybe that the government has that are making people feel uncomfortable. So
Absolutely.
Cool. Well, thanks so much for all of this. Touchy issue, but I think hopefully people will respect the conversation that we had. And, I think there's just as many questions as answers, but, I think you're going to bring a lot of clarity to a lot of listeners in understanding what some of the issues and the concerns are from somebody that's digging into this stuff very, very deeply and looking at it from a democracy, type perspective and a balanced perspective. So I appreciate your views, Caroline.
Yeah, well, I appreciate your questions. They were tough, but they were the right questions. So it was a good opportunity to have the conversation.
Yeah, I mean, part of what you do is as a host is you try to, ask some of the things that people that are listening are shouting at the screen asking, right? So it's not necessarily me. I'm trying to represent, the listeners by asking some of those questions as well. So,
for sure.
Folks, hopefully you got some good value at it. Curtis, take it away.
Right on. Hunter Conservationist Podcast is brought to you by J. Martin Taxidermy out of West Kelowna, BC. Make sure you check him out, jmartintaxidermy.com. He's on social media, J. Martin Taxidermy, Facebook and Instagram. Shoot him a message, have a look at his gallery, say, hey, thanks for supporting the guys and the conversations that they have. So as always, big shout out, big thanks to J. Martin Taxidermy, Jesse and his family for supporting us. So thank you.
Yep. Thanks, Jesse. On the taxidermy note, how this relates to our conversation, the Nijga people under their land settlement have their own lands, the Nijga territory. They have their own government. They manage their own resources, mining, salmon, wildlife, forestry, everything. They, from what I understand, would like to have grizzly bear guided hunts in Nijga territory as an economic and wildlife management tool. It's within their sovereign rights to make that decision because they are a sovereign nation. However, the province of BC has said, fine, go ahead. As soon as your first hunter steps off Nijga territory into the province of BC from having hunted a grizzly bear, we're going to confiscate it and arrest them, and charge them. So it's the polar bear scenario all over again. So these are some of the complexities of these things at play. That there are barriers that are put in place by governments, whether they're the U.S. government in the polar bear case or the BC government in the grizzly bear case. So that adds to the complexity of even when a nation does have sovereignty and their own government, there's another government on the other side of their borders that's wanting to still exert some power and control over them. So it's never a done deal. So, all right, folks, thanks for listening, and we'll see you in the next episode.